You are listening to Akeem El, an American national, but not a citizen of the United States. Hindsight Radio, the place for right knowledge.
Peace, everybody. This is Akeem from Hindsight Radio, the information station changing the nation. You can listen to my blog talk at blogtalkradio.com/hindsight 2020. There I do a show 7 p.m. Tuesday, which is this evening. I will be doing the show. And Thursday, 7 p.m. Eastern time. Although this week I probably will not be able to do a show because I have a 2-day seminar to do at the end of this week. And look forward to everyone that can make it. And thank you if you are going to attend. Today, we're going to talk about foreclosures again. Number 2. This is the second installment of, I don't know how many videos is going to come out of this. You know, I do these videos when I'm motivated by the Spirit or by the ancestors or the Holy Spirit or by God, whatever you want to call it. I call it motivation by the God in me through my ancestors telling me to give you guys this information. But before I get into that information, I'm going to read a passage from Psalms 23:4, chapter 23, verse 4. It says, He restores my soul. He guides me in the paths of righteousness for the sake of his name. Even though I walk through the valley of the shadow of death, I will fear no evil, for you are with me. Your rod and your staff, they comfort me. You prepare a table before me in the presence of my enemies. You anoint my head with oil. My cup overflows. Why did I read that scripture? Because many of you are going into the valley of the shadow of death, aka the courtroom. And in this courtroom, there's evil, all kind of trickery, all kinds of misdeeds and manipulation. So you got to go in there strong. Like, I can give you guys this information, but if your spiritual game is not tight, you will not succeed. Put forth the kingdom of heaven first, then these things will be added to you. So you got to put forth your spiritual work first. Spiritually put your armor on. That's first and foremost. I'll do another video on that, some of the things I do to give me strength. You know, there was a time in my life I wasn't guided by the Holy Spirit. Well, I was, but I was ignoring it. Let's put it like that. I think everyone is guided by spirit, motivation, whatever you want to call it, but we don't listen. We allow outside influences to slow us down. Okay? Well, today, we're not going to allow it to slow us down. We got work to do. Namely, I want to talk about foreclosures because a lot of people are losing their homes. Some people are losing them because they just can't afford to keep the payments. You know, someone loses a job, they just can't keep up. They got too much debt. And some people are losing their home because they're following gurus who say the mortgage is fake, they lost the note, they didn't lend you any money. And large majority of the people that's in this type of movement, that's why they're losing their home. They listen to some guy who doesn't own a home say, don't pay it, do this. And they pay these guys thousands of dollars to do processes that eventually makes them lose their home. And I'm sick of that. I'm sick of hearing those types of stories. And I'm also sick of those people who are have the nothing for something attitude. Okay, you took out this mortgage years ago and you had no knowledge of this information. Now you hear this knowledge, now you're using it as an excuse not to pay your mortgage. And then when you lose your home, you're saying the bank's at fault. No, the bank's not at fault. You signed that contract years ago. So if you were being honorable, you would keep your contract until you can figure out a way that you can either set it off or discharge it, somehow. Which that's remained to be seen because so many people say they can do these things. They have done them, but they're very few have offered any proof, valid proof, I've asked hundreds, maybe thousands of people, can you show me proof? They don't show me proof. Now, I had a couple, like I did a discharge video a couple of months back. Guys showed me what purports to be true, a discharge. And it looks 50-50, but it's still not solid evidence. It's still not solid evidence. So I'm still in my mode of no one has really given me rock solid proof that they've ever discharged or gotten rid of a house. No, actually, my buddy Gilbert has. And he's done it because the bank had done something that broke the rules of the Fair Debt Collection Practices Act or Fair Credit Reporting Act. And he got them that way, and then they settled. Now, I've heard of banks settling for less than what you owe. Now, I've seen hundreds of cases like that. Even in my case. That's what I ended up doing. I can't really go into that because I signed a non-disclosure agreement. But I can talk to you about my case, how it started, things, just the actual foreclosure case, which I'm going to show you today. I'm going to open up my case. I redacted a lot of information because there's other parties involved that did not give me permission to use their name in this video. So I redacted a lot of information just for the sake of protecting their identities and keeping their privacy. So today I'm going to give you a very good strategy on how to shut these cases down. I'm going to give you that. What is evidence? And that's the problem. You guys don't know what evidence is. And if you don't know what evidence is, you don't know how to stop it. Therefore, you lose. I would say majority of the time, over 90%, what these lawyers are presenting is not evidence according to the rules, but they're slipping by. One thing I want to add, do you realize that all of these lawyers are buddies? These judges, all of them are buddies. And this is a theory, but I believe it's accurate. I think they're all part of these little investment groups, and they look at your property, oh, I can make money off this, and they set you up from the very beginning to get your home. Pay off your attorney to set you up, because they never argue the right way. They know these evidence rules, but they're not using them to your benefit. Okay? So let's get in here. Let's get into this whole what is evidence and how y'all need to go about shutting it down. And get rid of all of these sovereign city conscious movement theories, because that's all they are. Many people go in the courtroom with all of these different arguments, and they always lose. Right? Let's go. All right. Let's move on to. Let's read the rules according to South Carolina. What is a self-authenticated evidence, and what is the requirement of authentication of identification of evidence? This is under Rule 902, under Rules of Evidence. Because if you go to South Carolina, let me just page back. Here's all the rules pertaining to evidence, court rules. Everything. Lack of personal knowledge. Let's read lack of personal knowledge, right? Let's look at that. A witness may not testify to a matter unless evidence introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may, but need not, consist of witness testimony. The rule is subject to the provisions of Rule 703 relating to opinion testimony by expert witnesses. So they must have personal knowledge of the facts. Banks always bring in their representative. Okay, what personal knowledge do he have of the information? Okay, let me go to my case, and I'm going to show you. This is my case. This is the complaint that they filed against me back in 2016. And let me give you some background on this. I ended up into this problem. I actually don't live at this property, but I still have an interest in the property. I have ownership with my ex-wife. We never separated the property. All of the legal stuff we didn't do. It's her home. And she wanted to do a modification, and lawyers suggested to her to do the modification. So she went for the modification, getting turned down. Of course, if you know about modification, you cannot make a payment until the modification is complete. They won't accept it. But they kept rejecting it. I think they rejected it like 4 times. So that put her like almost a year behind. So then they went into their foreclosure. Here we are. We ended up with this. This is how this happened. Wasn't because we trying to follow some guru discharge thing. No, because she knows nothing about this process. So me being who I am, I have to step in because my name's on it to help out. Now I know this information, and I'm going to show you guys how I started to fight this case, and how I allowed a lawyer to do some of the paperwork, and show you how they fight these things, and how it's the most ineffective way to fight them because everybody fights it that way, and they always, even when she did the paperwork, the attorney, I had an out-of-state attorney do the paperwork. She said, yeah, the best you can do is get them to settle. And this is, and she herself was in some type of litigation with her home. She was in it for 8 years, still fighting, but they hadn't been able to get it out. Lawyers know how to stay in their house and not make a payment. Okay? Because I guarantee you, if I look at her case, she probably was attacking the evidence. But she didn't do it for me. Okay, here it is. All right. Complaint. This is the complaint that they sent me for the foreclosure. And they have 2 causes. First, in any complaint, you have to have a cause of action. And you have to explain what a cause of action is. First cause of action is reformation. So, what's reformation? Let's look at reformation. You know? I always like to look up words. I don't like assuming stuff. You guys like to assume, and y'all like to just, reformation, then move on. Don't even take the time to look at what these people are actually saying. The actual process of reforming an institution or practice. So they're saying they're trying to reform an institution or practice. What institution they trying to reform? Well, we're going to see what they're talking about. Reformation. All right, let's go back to the document. And the second cause of action, foreclosure of real estate mortgage. Now, that reformation is a very important thing, because I didn't know what to do with that. See, when this happened, I was green. I ain't green anymore. After listening to many gurus, some of who I worked with, doing ineffective strategies, I decided to get down on my own work and study to fight my case. And this case has been dismissed. Oh, let me prove it real quick. Let's go. Where is it? Public. There it is. Let's go back to the beginning. You see, I've been messing with these folks. See it is dismissed. A lot of stuff's old stuff. Dismissed. See, my life's an open book. I don't hide stuff. I'm not like most. Dismissed per Rule 41. See, there's the disposition of the case. Can any of your gurus tell you that? They got a foreclosure case dismissed? Yes, of course it was dismissed because of, a settlement agreement we came up with. Not really, it wasn't dismissed because of that. It was dismissed because they didn't come to court on the trial date. And because the reason why they come to court, because what I'm about to show you. They couldn't bring real evidence to the court. But we had already worked out an agreement, so they probably said, no harm, no foul, just let it go. But when have you ever heard a lawyer not showing up to a court date? They didn't show up. And you'll see they didn't do that. If you go look that case up. There it is. Y'all can look it up yourself. Well, let's move on. Let's go to this. All right. The plaintiff above named complaining of the defendant's above named hearing alleges. So they're making a complaint about the above named defendants. Of course, I've redacted stuff up there. This is an action for the foreclosure of a mortgage upon real estate in Richland County, South Carolina. The plaintiff is a corporation or other legal entity duly organized and existing under and by virtue of laws of one of the states of the United States of America. You see, they're not saying United States. They say United States of America. Why do they do that? Let me stop doing it because I'm actually redacting stuff. Let me close that out so I don't do that anymore. United States of America, because they know they're not in the United States. They're in the country of South Carolina. That's all about status. But you notice how they put a United States of America is authorized to transact business in the state of South Carolina. And you notice how it's up and lower here. That's a whole nother subject too. But it's not all caps. So we're talking about the Republic state of South Carolina. You know what? Just because I said that, I have to take y'all to this. I have to show y'all this. I have to show you. Okay. I have to show you. See, y'all don't understand stuff like y'all should. Like people have taught you, if it's the state of South Carolina, that's the corporation. Not necessarily true. Because in the Constitution, March 19, 1778, it says the style of this country. I always do that, make by mistake. The style of this country, hereafter, the state of South Carolina, upper and lower. So what you're really looking at is state of South Carolina doing business as the state of South Carolina, all caps. See, that's the corporation. Whenever it's all caps, it's the corporation. When it's upper and lower, you're talking about the Republic. Pay attention to your documents carefully. All right, I just gave y'all a lesson on knowing the difference. So this actual complaint is styled in the Republic. Why is this in the Republic of South Carolina, the true de jure South Carolina? Because this is someone who says I harmed them, although it is a corporation saying that. Okay? Let's move on. The plaintiff is holder or otherwise entitled to enforce the note and mortgage described hereafter and that of the subject of this action. Some lien on or right title or interest in the real estate, the subject of this action may be claimed by the defendants herein. They're telling me I may have a claim as also. See, they gave me remedy there. Based upon the search of the public records of Richland County, all persons or entities having an interest or lien or possible claim in or upon the mortgage premises subordinate to the lien of the plaintiff as of date and the time of following of the list pendants herein have been made defendants. So what they're saying is, if you had a tax lien or something, they're going to have to make those people defendants. Okay? Just letting you know. The defendants herein described, if any, as judgment creditors, have by filing said judgment designated their attorney into the judgment as their agent for service of process under the provisions of SCC Code Ann 1535-840. You know they're using code annotated. Whenever you're looking at codes, look at the annotated codes. Side note. So what they're saying is whoever's got a lien, they have to notice that attorney so that they can get a judgment in their favor of any liens, any excess if they take the property and sell it. Boom, bam. Yes, I did have a lien of some South Carolina tax lien. I do. Which I'm working on. On or about September 18, 2003, there you go, Akeem Barber, I'm open book. I call myself Akeem L on the radio, but that's me. See, up and lower, not all caps. But if you're in a criminal case, that's going to be all caps. Made, executed, and delivered unto, that I think that's the bank name there. A certain note in the principal sum of $108,369, which with an interest rate of 5.5% per annum initially, payable in monthly installments, principal and interest of $615.31. Pretty low mortgage there. I don't have to do that. In order to secure the payment of the note according to the terms and conditions thereof, Akeem Barber and co-owner made, executed, and delivered unto the bank Inc. a certain real estate mortgage covering the following described party. And these are all the descriptions here. The mortgage was signed. See, this is what I was talking about in the first video. See how they're giving all of this information, how that mortgage got started, who it got assigned to, and how it initially ended up in the hands of the current supposedly note and mortgage holder. Right? I'm not going to read. I'm just giving y'all the ins and out. Showing y'all that right now this attorney is testifying to facts that he has no first-hand knowledge of. Now, he should have stated that at the beginning. Hey, I don't have first-hand knowledge, but it is alleged that all of these things have happened. But I'll produce at a later date all of the evidence that is to support these allegations. They don't say that. They say it as if he's talking like he was there on every transaction. And you have to point that out. That he was not there. Okay? All right? And all of this stuff he's talking about, denied. Attorney has no first-hand knowledge and has not presented any evidence to the contrary. That he have someone who has first-hand knowledge. Right? Because all he's talking about is what happened, what I was supposed to do. You know, boom, boom, boom. First course of action, reformation. I wanted to get to this so y'all can understand what this is. The plaintiff incorporates the allegation of preceding paragraphs as if repeated verbatim. Upon review of the loan origination documents and the deed and surveys of record, the plaintiff is informed and believes that due to inadvertence and error, the legal description contained in the mortgage does not make reference to the recording information for plat prepared for. That would be my name there and other information. The plaintiff is informed and believes that it is entitled to an order reforming the legal description to including the recording information for plat prepared for me, of course. The legal description should read as follows. Now, why did they put that as a first cause of action? Because if the legal description is not correct, according to the way it's supposed to be, they have no standing. Now, when I was fighting this case, I came to understand what the reformation was. So a lot of people don't understand what my strategy was. Okay, if they don't have it recorded, that my legal description of this property, it can never be foreclosed on, no matter what I do. Because they got to come in and get an order to reform it to the correct legal description so they can have it. That's why this is in this complaint. But see, when I first looked at this, I ignored that. And I didn't even argue that point. See, I learned from my mistakes. So what I'm telling y'all need to go back and look at what your documents say and make sure the legal description is correct, right? And if it's different than what they quoted, they can never get your property. I'll go more into that later. I just wanted to give y'all that. See, that was another way for me to shut them down. No order. This is, they're going after something else. See, whenever they sue for something, they have to have lawyers precise. It's got to be exactly the way it is. So go look at your documents and cross-reference and see what their paperwork is saying they're coming after versus what's on the record. And if it's not exactly, then they don't get remedy from you. It all goes to evidence. And you have to point that out. See, they're trying to say there's an error there. My job was, there's no error, this is right. They're coming out the wrong property. Boom, bye-bye. Sayonara, see you later. Go somewhere else with that. Boom. So that means, according to the records I have as a legal description and what's on file, and the records they have in their paperwork is incorrect. They're coming after the wrong property. Although technically you're sitting in the same place, but boom. All right, let me keep moving. Now this is the foreclosure. The real meat of this information. More allegations without proof. The plaintiff incorporates the allegation of the preceding paragraphs as if repeated verbatim. So he's repeating his outset information verbatim. With regard to the note mortgage, which are subject to matter of the suit, plaintiff and his attorneys have provided all applicable notice and rights secured as provided, otherwise have complied with all applicable federal, state, and local statute, laws, rules, regulations, orders, or other government directives. Now, he said that he's stating the fact that the mortgage holder did all what they could before they came to the foreclosure. They got certain things they got to do before they go for foreclosure. He said all of that. Did you notice something that's missing here? There's something missing here. He didn't say see exhibit, whatever, as proof. He's just making a statement. That's not evidence. That's a allege or allegation or an assumption that they did everything right. And you have to point that out, that they didn't follow that rule. Okay, let's keep going. The installments of principal interest which became due February 1st, 2015 have not been paid through demand for the prepayment thereof and been made, and the plaintiff as a holder of note mortgage elects to and does declare the entire balance of said principal interest due and payable at once, and that there is now due and owing and unpaid upon the said note mortgage the sum of $86,100 blah blah blah. That's what they say in IO. Okay. Another allegation. He's only going off of a record that came out of the computer. He hasn't got my side of it, so it's another one. Pursuant to the terms of the mortgage, plaintiff has employed counsel to prosecute action, and under the terms of the note mortgage, plaintiff's counsel is entitled to reasonable attorney fees and costs of this action. Plaintiff may be forced to pay sums for taxes, insurance, and costs for securing the property, which sums, according to the terms of mortgage, should be added to the amount of the debt. Plaintiff's right to personal or defensory judgment pursuant to the codes. Wherefore, having fully set forth this complaint, plaintiff prays that the honorable court inquire into the matters as set forth herein. Issue an order reforming the legal description to include the recording information for plat prepared for. So they want to update everything. Right? Ascertain and determine the amount due upon the note mortgage held or being enforced by plaintiff together with attorney fees and costs of this action. Declare plaintiff's mortgage a first mortgage lien on subject property and render subject of a foreclosure for amount so found to be due owing. Blah, blah, blah. Y'all get the point. So, at this time, in here, they are saying no exhibit, say go look at this exhibit, this, show this. Now, I'm going to show you what they gave as proof. I'm going to show you. Let's go here. This is my motion to dismiss, but I want to go because I put exactly what they gave as proof and use it against them. Exhibit A. That's my motion to dismiss. Boom. And how I argued it. And I'm going to go over that in a second, but I want to show you what they used as evidence. Here. This is all corporate assignment of mortgages. I redacted a lot of information. I just want y'all to take a notice of all of this. You know, they do have the book stuff up here at the top here. But notice there's no seals on this stuff, right? No seal. Nothing. This is basically what they put in as exhibits. Boom. Okay. I gave it to you. I scrolled through it. B. That was an email, blah, 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 that went on between them. We'll go over that. So, according to the rules, what is evidence? Let's go to evidence. Requirement of authentication or identification. They're saying this is Rule 901 in South Carolina under evidence. It says public records or reports. So when they pull out a document that's recorded, like your mortgage and all of that, and they put it at the county, this is what it's saying it needs to happen. Public records and reports. Evidence that a writing authorized by law to be recorded or filed, in fact recorded or filed in public office, or purported public record, report, statement, or data compilation in any form is from the public office where terms of nature are kept. It's saying the requirement. This is required here. The requirement of authentication or identification as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what its proponent claims. So they have to authenticate where this came from and identify where it came from. Okay? They have to give a statement saying this came from such and such place. They can't just place it on the record and say this is it. They have to have a statement identifying whether the exhibits I came from this county, blah, blah, blah. Right. So basically, that's not evidence, and you need to point it out. All right? Okay, let's keep going. Let's go back to my case. Where should I start? Here. Let's go with motion to dismiss. So I filed a motion to dismiss almost immediately. Reason why you should file a motion to dismiss, because it gives you an extension of time to give an answer if your motion to dismiss doesn't work. All right. In South Carolina, you got to do these motion cover sheets, as you can see. But here we go. Defendant's request for judgment on motion. Well, let's skip that part. Let's go straight to the motion to dismiss, because I had to go back a couple of years after the fact and get a judgment on a motion, and I'll go over that in a second. See, as I was learning, this is the motion to dismiss. And this is what the attorney did for me. Because I was having to do it, then I tweaked some things. And it says defendants, propria persona, pursuant to 12b6 SCRCP and Rule 12b7 SCRCP, hereby submit their motion to dismiss the complaint filed by plaintiff, on the grounds that plaintiff lacks standing and failed to join the necessary party. In support of their argument, defendants state as follows. 1. Applicable issues of law. Plaintiff lacks a standing to sue defendants as it was not a party to the note attached to the complaint. See, when you attack it like this, you're saying that note is valid. So I just authenticated their evidence. See, that's where I went wrong by using an attorney. Because they go after the usual way. And the reason why attorneys don't attack stuff that way, because they do this, because they're doing the same thing to other people. So they're not going to show their hand that really what they have is not evidence. Okay? That's why you got to do this yourself. In South Carolina, the prosecution of a foreclosure action is by the owner and holder of the mortgage in the note. Plaintiff is not entitled to maintain this action in which it seeks to foreclose on note which plaintiff does not own. Carpenter v. Logan, 83 U.S. 27112 LED 313 1872. So she pulls out an old case from 1872 to support this number 2 statement, right? And this is typically how people argue their mortgages. This is typical. It is well established law that the plaintiff must own the note and the mortgage to foreclose on the property. Standing requires that the party prosecuting the action have a sufficient stake in the outcome and that the party bringing the claim be recognized in the law as being the real party in interest entitled to bring the claim. This entitlement to prosecute a claim in the court rests exclusively in those persons granted by substantive law the power to enforce the claim. See, all this, if you don't know anything, all this sounds great and seems like it'll work. Specifically in the pivotal 9th Judicial Circuit of Common Pleas of Charleston, South Carolina, Carolina case Judge J.C. Nichols Jr. stated as follows. The idea that the mortgage filing note is one which has been repeatedly confirmed by our court. South Carolina recognizes the familiar and uncontroverted propositions that the assignment of a note secured by a mortgage carries with it an assignment of mortgage. However, Carpenter v. Logan, 83 U.S. 271, 16 Wall, 27121 LED, 313, 1872. Quoted by plaintiff's counsel in this oral argument and brief clearly supports the notion that the plaintiff must clearly own the note and the mortgage to foreclose on the property. Plaintiff failed to show that it owned the mortgage at the time the complaint was filed. In his complaint, plaintiff merely contends, Section 3 of his complaint, that its holder has the right to enforce. Furthermore, the mortgage of the case shows Mortgage Electronic Registration System, Inc. MERS to be the mortgagee. This was confirmed by plaintiff's counsel in oral argument. MERS is never mentioned on the note. Same thing with mine. Identical. Then they go to douchebag, right? Now, plenty of people have used these arguments and they didn't win still. Indeed, it is clear that to have standing in this foreclosure case, plaintiff must not only be the holder and owner of the original note, but also the mortgage as well. Plaintiff's complaint in this case fails to meet this criteria. Plaintiff lacks standing to initiate and prosecute the foreclosure and dismissal pursuant to Rule 17A, Rule 17B6, SCRCP is appropriate. Furthermore, to establish standing to foreclose, a lender must show that at the time it filed its complaint for foreclosure, it had a right to enforce a note which represents a debt and ownership of the mortgage lien upon the debtor's property. See, this whole argument is challenging that the right person is not coming after me, but not challenging that what they're using as evidence is really evidence. That's the problem with this argument. See, if I would challenge the evidence first, then move on to this. Here, there is no evidence that the plaintiff owns a note on the property as issued on this case. Specifically, plaintiff have not attached any evidence or documentation evidencing the assignment of note to the plaintiff. The only documentation provided by the plaintiff is the assignment of the mortgage, not the note. See Exhibit 1 attached here too. According to the documentation attached to the complaint, the note was assigned to the Secretary of Housing, Urban Development on July 26, 2015. See Exhibit 2 attached here too. No further documentation of assignment of note was provided. Moreover, there is evidence that the plaintiff does not currently hold ownership of either mortgage or the note. Specifically, defendants received a notice of sale of ownership of the mortgage. Notice of sale dated February 8, 2017 said that the loan is at issue had been sold to the loan had sold to that loan was sold to, and is naming who did that right there. So what they did was they started foreclosure, then they sold it off to the trust. You see? But they still had the original plaintiff in place as the coming after me. That's not allowed. You need to point that out. If they got to join a party. So I can keep going on and on. Y'all saw my case. Y'all can go pull this stuff and read it if you want. I'm not going to read it. I'm just giving y'all an idea. And then I put the exhibits in showing the different transfer and how they didn't actually own that note. Okay? That's the exhibits. You get the point. This video is getting a little long. Now, this is a communication from the court to the lawyers. And the lawyers sent this to me. I have enclosed a copy of the email trail with the court's today's date in the above reference matter. This is just to show you how the courts help these lawyers and show you how they lie. Right, here it is. It says, I redact I represent the plaintiff in the above matter. I am aware that the pro se borrower in this foreclosure action has filed a motion to dismiss. However, my client does not consent to dismiss this action. I have not received a proposed order, which would not be signed in any event. The case should be stayed pursuant to the SC Administrative Order concerning foreclosure intervention, as a request was made by the defendants in that respect. I will forward this email chain to the pro se defendants, but a consent order to dismiss this matter will not be forthcoming. I will further request that the proposed order sent to Judge Bennett along with the copy of this email be made part of the court's file. Please do not hesitate to contact me. Now, let's see what started this. Good evening, counsel. This is coming from the court. Received an order in above reference matter. The order states that the plaintiff does not object to defendant's motion to dismiss, and for the court to grant defendant's motion to dismiss has not signed the order. The envelope attached looks like the order should be returned to. That was the attorney. Can you please attach the signatures of all parties on this case and please attach a cover letter? In addition, the public index notes that defendants in the case are pro se. Please ensure that they get a copy, basically. What she said is she don't have my information, but my information is on the motion to dismiss. So how you not having my information? Let's go back to the motion to dismiss. Let's go. Let's go back. How do you not have that information? Give it a service. This is the motion to dismiss here. She said that she didn't have my information. I filed. You got to file give them your information. I don't see it here and here where I gave them my address and information, but they have my information. Which they claim they didn't have it. So he forwarded me the information. See, this is how they help them. They help these people win their cases. How do you not have it? It's a foreclosure property. You got my address on record. And if I gave you the proposed order and everything with it, you have everything. Okay? So, anyway, let's keep moving. Now, this is what happened here. Now, this is the order to rescind order because they tried to change the plaintiff. So, let's go to the very beginning of why I'm going over this. So, I did this motion to dismiss in February 24th, 2017. So, I had to go defendant's request for judgment on motion dated February 24th, 2017. This is this year, August 19, 2019. So what happened was I did this motion to dismiss. They never answered. So I went in there and told them, this is an action to foreclose a mortgage on real estate located in Richland County, South Carolina. Subsequent to the initiation of the suit, defendants filed a motion to dismiss dated February 24th, 2017 because they didn't have standing. Whoever that bank name lacked standing to foreclose. Exhibit A attached. Plaintiff was aware and deliberately failed to respond to the above-mentioned motion. See attached ex parte communication between plaintiff's law clerk and clerk of court dated March 22nd, 2017. See Exhibit B attached. So I pointed out that they had an ex parte communication, which they're supposed to talk to me as well as the attorney. They can't talk to the attorney without letting me know what they're talking about. They were supposed to do due diligence and locate me before they even sent that email, but they didn't. Plaintiff tried to substitute plaintiff for blank, 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 solely as trustee, blank, blank, blank. That motion was granted on October 23rd, 2017. Then it was rescinded on October 31st, 2017. Take special note, the Honorable Judge agreed and signed an order dated October 31st, 2017. See attached signed order, Exhibit C attached. Finally, blank, blank, blank is no longer the real party of interest. Pursuant to SCRP 12B7, SCRP Rule 19, SCRP Rule 56, defendant seeks judgment on motion to dismiss dated February 24th, 2017. Then it's signed. Then I have, who I sent to certificate of service. My address will be there. Here's the exhibits. That's the motion to dismiss that I did on that date, which I just read. All the assignments, the ex parte communication, which I just went over. And let's get to the other stuff that they. Exhibit C is order to rescind, order to substitute plaintiff. This is an action to foreclose mortgage on real estate located in Richland County. Subsequent to the initiation of the suit, defendants filed a motion to dismiss on the grounds that plaintiff failed to substitute real party in interest on February 24, 2017. Plaintiff failed to respond in a timely manner. Defendants was not provided time to object to order to respond in a order as required by law and did not consent to this order as outlined in plaintiff's motion. Defendants moved pursuant to SCRP 17A and SCRP Rule 12A to rescind order substituting plaintiff. So they filed a motion to add the new person on after I did my motion to dismiss because they hadn't substituted. And they said I consented to that. So they sent a proposed order saying that with available consents. My signature wasn't on no proposed order, but they stamped off on it and gave it to them. But with me, they sent an email to them asking them to get a signature. They didn't do that to me. Okay, see how they play? How they work in favor of these people? They automatically take their word for it. But the court agreed with me. So they signed off on my order to rescind. So it was rescinded. Order to rescind to plaintiffs. Order to rescind, order to substitute plaintiff. There it is. There's the order. Right there. And you notice I put in there that I filed a motion to dismiss here. I filed a motion to dismiss. I slipped that in there that I filed the motion to dismiss and they never answered. And I got the judge to sign off that they didn't answer. Boom. So I was setting them up. Because this was going to be my ace card if we ever went to trial. Listen, you guys got to get rid of this. I got a judge's order who says that they never answered my motion to dismiss, and this case needs to be dismissed. This is why they didn't show up. Because they knew I had this order. All right. That's done. I gave y'all that. Which one is this? What is this here? Motion. Okay. You also, when you have these types of cases, you got to strike that evidence and tell them why. Now, this is when I started doing things myself because it was increasingly hard to get a hold of the attorney. She was hard to get a hold of, whatever, and I had to start doing my own thing. And you could tell by the writings that it's not done by a lawyer. Okay, defendants, blank, filed this motion to strike evidence and exhibits. All evidence exhibits is hearsay and not facts before the court presented by plaintiff's attorney on the following grounds. The name of the law firm are debt collectors as defined by the Fair Debt Collection Practices Act. And this is a direct quote. The term creditor means any person who offers or extends credit creating a debt or to whom a debt is owed, but such term does not include any person to the extent that he receives an assignment or transfer of debt in default solely for the purposes of facilitating collections of such debt for another. So whenever a debt is assigned to someone to collect, when it's in default, they're a debt collector. Blank do not have first-hand knowledge of the fact. Trinity v. Pagliaro's statements of counsel in their briefs or arguments while enlightening to the court are not sufficient for purpose of granting summary judgment. All evidence must be supported by affidavit or deposition. There is no support by someone with first-hand knowledge of the fact stating these documents are true or correct. Under penalty of perjury, attorneys do not get to testify. They must present sworn affidavits or depositions. Boom. Then I said blank, not as an individual capacity, but solely as trustee. For this trust, assignment of mortgage loan was done while loan was in default. Fair Debt Collection Practices Act. Here it is again. All I did, the term creditor means any person who offers or extends credit creating a debt or to whom a debt is owed, but such term does not include any person to the extent he receives an assignment or transfer of debt in default, solely for the purpose of facilitating collection of such debt for another. So he is a debt collector. There it is. The assignment, the contract of this alleged creditor, therefore, do not have a binding contract with the alleged plaintiff. Certificate of service, boom. And let's see here. Then I put my cover sheet to show what I was filing. Because I did a bunch of motions. Objection to motion to substitute plaintiff. Order rescind order to substitute plaintiff. Rescind substitute plaintiff with certificate of mailing. Order to compel discovery with certificate of mailing. Motion order to strike exhibit with certificate of mailing. And then, they charge $25 per motion. Now that's misspelled. Please, these filings orders meet your. I had that misspelled. See, I got misspelled, but it still worked. It ain't about the spelling, it's about the intention. It still worked. I got them to give me an order saying that they defaulted on my motion to dismiss, plus they dialed back the plaintiff to the original one, because you have to keep it to that original one, because that one is the one that doesn't have standing. Even the new one doesn't, but it makes your job easier. All right, there you go. There you have it. All right, to continue with the the evidence exhibits that must be done on personal knowledge. Look at Rule 602 of lack of personal knowledge under evidence. A witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Evidence to prove personal knowledge may, but not need, consist of witness own testimony. So they gotta have personal knowledge. So when the bank brings in a corporate rep saying all he's going to testify is what's in their computer, but he does not have personal knowledge of the actual allegations that are in the computer. Why doesn't he have first-hand knowledge of that? He was not sitting at that table when that transaction took place. When you allegedly contracted with this company or this bank. See, in order to get someone first-hand knowledge, they have to get everybody in that room at the time that contract was initiated. Why? Because that is the basis of their evidence. They're saying you did this on such and such and such and such and such date, and here it is recorded over here that you did this. Okay, it's recorded over there, but you guys recorded that. I didn't record that. You recorded that without my knowledge. See how you got to attack the evidence? So they got to bring everybody in the chain of all of that evidence, substantiate that evidence. You must challenge it. You must say that's not evidence. You need someone with first-hand knowledge. Move for dismissal due to lack of evidence. Evidence must be authenticated. If it's a public record, it must be authenticated. I showed y'all that in the rules. With the court seal. Specific parameters is on that. Let's see what this is. All right. You guys got to, let's go. Let's see. Let's do this again. Let's go back. Why is it just going back? Rules of evidence. Oh, it's going back too far. Now my computer wants to move a little slow. Now I can't even get back to it. So let's just do South Carolina rules of evidence. Click it. All right. There's all your rules. And I just read the 602. And here's what has to happen. 603 says, before testifying, every witness shall be required to declare that the witness will testify truthfully by oath or affirmation administered in a form calculated to awaken the witness conscience and impress the witness mind with the duty to do so. Okay. Attorney sitting on your side of you, telling all of these stories. When did he ever swear an oath or affirm that he was going to tell the truth truthfully? So that means none of his evidences can be considered as truth. None of it can be considered as truth unless he swears to it. If he doesn't do that, everything he's putting in his paper is unsworn testimony. Go to the first video. I did the case law on it. Read it. Trial courts cannot consider unsworn testimony, unsworn exhibits as the basis of their decision. They can't consider it. And they are considering it. You must appeal it. But you must object to it in the courtroom. Hey, objection, Your Honor. Is the attorney going to swear in before he testifies? You say it like that. We know he can't swear in. Only thing an attorney can swear to is what he has firsthand knowledge of. Actually, I did have an article that I wanted to read. It's on LexisNexis website. Attorney declaration or affidavit. A declaration or affidavit from an attorney representing a party in the case must meet the same requirements as a declaration from any other witness. Counsel really has the personal knowledge needed to properly testify the facts in the case. For instance, counsel's declaration in opposition to summary judgment was not entitled to any weight because counsel lacked personal knowledge of the facts stated. So, if you would object to what it's saying, if you object to a summary judgment, all you're getting is the attorney coming back with his answer. He doesn't have first-hand knowledge of nothing. And all you need to attack is, hey, we can't consider this. He doesn't have first-hand knowledge to object to my response to his summary judgment. He doesn't have first-hand knowledge. An attorney can authenticate documents of which the attorney has personal knowledge, such as documents created by the attorney. An attorney can also authenticate documents by attesting that the documents were produced by the opposing party in the litigation, provided the attorney has personal knowledge of such fact. An attorney cannot authenticate a deposition transcript even if the attorney was present at the deposition. A party's attorney can submit a declaration on certain matters. An attorney can offer testimony in matters of which an attorney has personal knowledge, such as interactions with opposing counsel. That's why you got to be careful what you're talking to and saying to an attorney. They will use it. An attorney declaration can attach documents about which the attorney has personal knowledge, such as the opposing party's discovery responses or written communication with opposing counsel. If a document's authenticity is stipulated to or it's self-authenticating, say so in the declaration paragraph that it identifies the document attached to the attorney declaration. So he has to declare if so he's presenting self-authenticating documents, and there are self-authenticating documents. A lot of them. I'm going to show you. So he's got to make a declaration to that. This is self-authenticated where he got it. In my foreclosure, he never said, oh, this I got out of the record with self-authenticated. He never said that. See, they're lazy. Okay, let's go back to the rules of evidence. And it has in here self-authenticating documents. Let's find it. Self-authentication. Right there. And it tells you what's self-authenticating, which I already said, certified copies of public records. Y'all didn't know newspapers and periodicals are, right? Acknowledged documents that are notarized. Let's go back to what's not. Requirement of authentication, or I did that earlier in the video. Okay, we already went there what the requirement was. Okay, we did this already. Right, there you go. There you have it. I think I made the video long enough just to give you the point of what you need to do. Chase down that what they call as evidence is not evidence. Really, who's foreclosing on you, truthfully, is the attorney. Yes, he says he's representing this bank, blah, blah, blah. But these guys are after your properties. They're involved in these investment groups. And they get first look at dibs on all of these properties. They know what's what. And they're trying to steal your properties through these banks so that all of them can win and you lose. Arm yourself. Study. Consider yourself approved. No one is going to help you win or you're not going to win your house without your energy invested into it. Meaning, type your own paperwork. Stop paying people to do stuff for you. I did all of that. And I just got on and said, I'm going to study my stuff and I'm going to get it done. And figure out how to type these paperwork. And what I do is effective enough to get what I need done. Why? Because I took the time to study it. Practice make purpose. If you're going to make mistakes, it's okay to make mistakes. Mistakes is what makes you better. Mistakes are a good thing. If you're a person who is afraid of making mistakes, you're a person who will lose all of your life. You will never get anywhere without making mistakes. It's the natural order of things. All right, once again, peace. You can go to akimel.com for consultations. You can go there. I got certain products there that you can get. Actually, I'm going to set up a foreclosure forum, some to that effect, really to help people with their foreclosures. I'm not going to do them for you. What I might do is do some case searches to help you in the case, but most of it we're looking for unsworn affidavits, unsworn statements, and using those cases in whatever state you're in to fight your case. If there's no evidence, there is no case, and that's all you need to attack. Stop with these, that I need the wedding signature, because you're basically saying, if you can prove that the wedding signature, then I'll agree with you, right? No, you want to say, listen, all of this is not fact anyway. I don't care about that, signature stuff. He's presenting unsworn affidavits, unsworn statements. He's the one testifying, not the actual so-called victim or the plaintiff or the bank. He's doing all the talking. Bring everybody that had a connection to this note into this courtroom. Everybody, they can't do that. It's impossible. And that impossibility is your remedy. And you hold these courts to the fire to follow those rules. Don't go in that court punking out, acting like they owe you. So you're their servant, because that's what they're gonna do. They're gonna try to intimidate you, but it's your job to make it happen. All right, akimel.com, blogtalkradio.com/hindsight 2020. There you will find all the information you need. You can listen to the show once again. I told you guys, if you want to ask me a question, akimel@protonmail.com. akimel@protonmail.com. I've already gotten a couple of ridiculous questions. They will not be answered. I'm not going to even read them. People, you just be surprised what people's minds are thinking, and they want you. If you don't hear an answer, it was a ridiculous question. I'm only answering questions that are coherent. If you ask me about discharge, don't even waste your time. Okay? You got foreclosure questions. You got debtor party debt collection questions. You got credit questions, related to your credit, things like that. Court procedure questions. I can help you. I'm not a lawyer. I just must reiterate that. But I can show you where to look to help you. All right? Everything I teach comes out of their rules, like I just did. I'm showing y'all on screen my case and how I fought it and got that ultimate dismissal. All right, peace. Have a good one.